Hi, I'm Chris Said, Los Angeles burglary attorney, and welcome to CBS Law, where we deliver results, not promises. First, I'll go over the most common burglary charges. Second, I'll go over common defenses we employ every day at CBS Law for burglary cases. And third, we'll go over some common sense measures you can take if you find yourself being investigated or charged with burglary. First, let's talk about the most common burglary charges. It's a violation of Penal Code Section 459. Now, burglary can be subdivided between first-degree burglary and second-degree burglary. The difference between the two is whether the structure is someone's home or not. So let's start with the first-degree burglary. First-degree burglary is entering into a structure that's someone's home with the intent to commit a crime inside. Usually that crime is theft. First-degree burglary has been labeled as a serious felony under California law, which means it's a strike. Now, the consequences of first-degree burglary are a low term of 2 years, state prison, a middle term of 4 years in state prison, or a high term of 6 years in state prison. And those terms would be served at halftime. Second-degree burglary is entering any structure that's not someone's home. So that could be a business or a car. It involves entering a piece of property that's not someone's home with the intent to commit a crime therein. Now, second-degree burglary can be charged as a felony or as a misdemeanor. If it's charged as a felony, the consequences are a low term of 16 months in county jail, a middle term of 2 years in county jail, or a high term of 3 years in county jail, all at halftime. If second-degree burglary is charged as a misdemeanor, then the maximum term of imprisonment is 364 days in county jail at halftime. Let's talk about some common defenses that we employ at CBS Law for clients charged with burglary. The first and most common defense is that our client did not enter the property. In other words, they had an alibi witness showing that they were in a different location at the time of the alleged crime, or they didn't physically enter the property. Another common defense is that, yes, they entered into the property or into the structure, but it was to retrieve property that they had a claim of ownership over. And we often see this in domestic situations where there's a dispute between two partners or a family, and someone's entering the property to retrieve their own property. The other common defense that we see in these cases is that they had permission to enter the property. In other words, if the owner of the structure invites someone in or gives them permission to enter to retrieve their property or otherwise, that is a defense to burglary, whether it's first-degree burglary like someone's home or second-degree burglary like someone's car. Now, the resources we utilize to defend these cases are first investigators to interview witnesses and evaluate what actually they saw. Second common type of defense resource that we employ here are expert witnesses. And those would be forensic investigators that can examine any surveillance video, but also fingerprint experts or DNA labs to try to dispute any forensic evidence showing that our client was actually at the scene. Now, some common sense measures you can take if you find yourself being investigated for or charged with burglary. Well, first and foremost, don't talk. Don't talk to the police. Don't post statements on social media. Don't talk to anyone about the allegations. Second, if the allegations relate to a family member or a partner or someone else where you had permission to enter that structure or retrieve your property, don't delete anything. And then third, most importantly, call CBS Law now at 213-800-8005 so we can get to work investigating your case and building your defense.